People suffering in silence. People suffering in silence, people not coming to the courts is no answer. You should be thankful that everybody did not come. Otherwise, you will be flooded with the cases. But brother, once the issue just on the part of the Public Service Commission to talk about legalities, is it right on the part of the Public Service Commission who failed miserably several times, Malad, to talk about delay? In every case, there is a delay in filing counters by them, and they talk about the delay. And most important thing is there is something called as WH. This will take a minute of WH. That is who, where, when, and what.
Yes.
All these WHs will apply here. Now, WH, what is your authority? Number one. And what are you doing? And what are the, what are you doing to yourself, first of all, and to your reputation? And when the next issue is why are you doing, the answer is public interest. I fail to understand how it is a public interest when the whole thing is contrary to public interest. And most important thing, how? How is it possible that you cannot even conduct an examination properly, being a constitutional body? Therefore, all the WHS questions will come and arise, and then you have the audacity to say that we are wrong in approaching the court. We knock the doors whenever it is possible for us before it is over. It is not as if appointments are over. It is not as if everything is over. We are at the right time seeking to get it right. And you'll also kindly recall, the Honorable Supreme Court, in the earlier case, set aside the whole process.
Yes.
And therefore, the question of delay, hot and cold, these technicalities and the legalities will not apply to an organization who has no respect for the legality. And most important thing, there is no answer in the counter. Having gone to the Supreme Court to sustain the earlier notification, kindly appreciate this. Having gone to the Supreme Court to sustain the earlier notification, they withdraw the case and they cancel it. Is it not tricking the courts? Is it not a overreaching tendencies? Does it not come within the meaning of contempt? You have approached the court saying that Justice Madhavi Dev is wrong. You get it stamped, approved by withdrawing, and
Yes.
you have to implement it. What does it say? Notification. My friend was arguing, saying there is no mention about notification. There is no necessity. There is a direction to conduct inquiry. But what do you call it? Sorry, the written examination. Did you take permission from the learned single judge? No, madam, we are not trying to conduct. We will withdraw the whole notification. Did you take? No. Therefore, it's a contempt. It's a overreaching tendencies. It is no respect for other constitutional body, the High Court, being a constitutional body, claiming themselves to be a constitutional body, and doing all unconstitutional things.
Yes, sir.
Therefore, the cancellation is what I seek, your lordships, indulgence. It might look a tall claim, but your lordship can appreciate, that will put a knot to everything, and then everything can be sorted out. We are only trying to help the Public Service Commission so that they will do it properly. Because they are not able to do properly, matters will get to litigation once again. We are seeking your lordship's indulgence to make it proper. Now, in case if your lordship thinks that cancellation is okay, then the next case, next point I'm raising, is that segregation of 503 in 260.
Yes.
The answer given by them is we want to make equals everybody. Lordships knows, Article 14 says unequals cannot be made equals and equals cannot be made unequal.
Yes.
Now, We were the candidates who were eligible as on 1/7/2022 under the earlier. Vote bank. Cancellation, you lots may have to understood from the angle that they want to bring these subsequent changes, which is not possible because they could not have been. Lord Lordship knows the judgment of Surendra Reddy's case.
Yes.
Lord Lordship knows about judgment of Surendra Reddy. Adi bandi. My
Group
colleague
two,
will.
group two case.
Group 2 case where
Yes.
where when 124 GO is sought to be made applicable midway through, the
Yes.
Supreme Court said you cannot made applicable, you cannot make it applicable. Same thing applies to the where is the necessity for bringing 29 or this 33. You cannot bring these things. Therefore, they have cancelled it.
Yes.
But in that view of the matter, even this can be done by Lordships, saying that in so far as 503 vacancies are concerned, the 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 33 is not applicable, and for 60 it is applicable. Kindly give me 2 more minutes, Lord. I'll conclude. Lord,
Yes.
extension of time. Extension of time. I'm asking for extension of time now for two
Yes.
more minutes,
Yes.
two, 2 to 3 minutes. And the ground I'm going to talk about is Lord, extension of time granted by Public Service Commission.
Yes.
Lord, by extension of time, more than 30,000 people seeped in.
Yes.
They should not have done it because, Lord, under the notification, if your Lordship takes the notification, kindly take notification, Lord.
Yes.
7, page 131, my writ petition.
Yes. Yes. 131. Yes.
7.12.
Yes, sir. Great.
No correspondence will be entertained to accept application oblique extend the date after closing the date of submission of application. Manoj,
Yes.
each time the Public Service Commission makes a trump card argument saying that this is in accordance with notification, we cannot go beyond notification. And the notification is like this, therefore we cannot. Manoj, they cannot give one, they cannot say that one day also, Manoj, they cannot give 1 hour also. Because, Manoj, this is what specifically says so and the time is fixed. And now they have given 2 days, which expanded, which is contrary to 7.1. my lord, we are about let us say 3 lakh people responded. So
Yes.
there may be 10 lakh people waiting. You have not responded. So competition has to be confined only to that. And you have yourself given a notification saying that we will not extend, there will not be an extension. You have violated. Under what authority you have violated? Under what power you have violated? And above
Yes.
all, my lord, now in the counter again, they try to expand it. They say we refer the matter to Center for Good Governance. And kindly see, my lord, this is improvement. In the cancellation, there is no mention about Center for Good Governance. Now in the counter, they say we refer the matter to Center for Good Governance. There is a technical glitch. Everything is a glitch only. Public Service Commission has a glitches all through. But just because some technical glitch, somebody who is at the 11th hour doing, and then he is not able to apply, he requests, you give. And what about those who have applied in proper manner? So you are always interested in those who are late, those who have no merit. Therefore, Public Service Commission's approach to the whole process is most important thing. It goes to the root of the matter because I failed to, sorry, I did not say this. This is a fraud on recruitment process. Once it's a fraud on recruitment process, it's a fraud on constitution. Once it's a fraud on constitution, and the constitutional mandate that they have to do a fair job, your lordships can deeply go into the matter, lift the wheel and see the whole thing and then trash the whole thing and ask them to do it properly. Now, fourth thing, my friend anyway will address. He is concerned, kindly appreciate, key aspect. The key aspect, my friend is repeatedly saying objections are not filed, objections are filed, somebody got marked. These are, it's not a question of one or two. Once the question is wrong, Rama's next brother is Lakshman. If that is instead of Lakshmana, you say Hanuman. Everybody puts in and nobody objects. Does it become valid, my lord? Just because nobody objected, whether the wrong question or wrong answer, does it become valid? It's not a question of how many people have. But kindly see the counter. What they see is 3 lakh people wrote, and only 1,700 people applied objections. Therefore, some people who have not applied, and then they say only 0.001 objected. It's not a question of how many. It's a question of whether it is right or wrong.
Yes,
so,
sir.
petitioner number 1 applied. He did not object. He applied. He gave a correct answer. He got a good mark. But it's not a question of I am getting a good mark. If the wrong answer gives me a good mark, I am not entitled. Let the correct person be selected.
Yes. Yes,
If
sir.
I am given a wrong mark for a wrong answer, let it be
Yes,
removed.
sir. Yes.
And therefore, now coming to the questions, my friend will address.
Yes,
But
sir.
then, just give me 1 minute. There are 2 questions, forgetting about all 10 or 15. The constitutional question that which article is not referable to that particular aspect, they rely upon, the joke is, they rely upon the National Commission's website.
Yes.
Can
119.
the National Commission's website be a valid document, or do we have to understand? But what they say is, for a minute, if your lordship takes their counter, they say, I admit the fact that insofar as other things are concerned, there is no direct connection, but still we are accepting because National Commission has said it. As Shiva said, my friend Shiva said,
Yes.
some of the issues may be referable or useful for the, it's a specific question for scheduled castes,
Yes.
welfare. So
Yes.
what we have to understand is, only with regard to specifically given to scheduled caste, has to be understood. That is one aspect. The
Yes.
so these are the questions, we are not asking you lordships to delete just like the Supreme Court did. These are the matters which have to be referred to the expert committee, because kindly appreciate this.
Yes.
First preliminary key is issued. Then objections are called for.
Yes.
Matter is referred to again expert committees. 3 questions were deleted.
Yes.
That doesn't mean, that does it not mean that first experts are wrong? When the first experts are wrong, second experts can also be wrong.
No, on the basis of first expert committee report, they have deleted 3 questions.
No. After the first expert committee, they deleted. But who has fixed it, my lord? Experts only, non-experts. Kaadu kada?
Yes.
They were also experts. So
Yes.
who are these great experts, my lord, who are always expertised in doing wrong questions and wrong answers? They are expertised in that, seems to be.
Yes, sir.
And then now, therefore, we are asking only an independent body to look into. We are not saying that we are right. There is at least a doubt.
Yes,
Therefore,
sir.
the matter has to be referred to an independent body. Therefore, my lord, you are anyway very useful to, my lord, so, what you call, you are always accustomed to delaying the processes, getting the examinations cancelled, so you don't have to be overawed by the examination to be conducted soon. Doesn't matter, 2 more months or delayed, whatever it is, my lord, the whole thing has to be stayed or stopped so that, my lord, your lordships can, the whole process can be done properly as your lordships direct, as we pray. My lord, in so far as questions are concerned, my lord, my friend will address.
Yes.
Deeply obliged.
Yes.
My lord, before I start replying to the questions, my lord, I would like to answer 2 questions regarding the very fairness with which the Public Service Commission deals with the entire matter. This also goes to the root of the matter. My lord, though I have not specifically raised the cancellation,
Yes.
my lords may kindly see what my learned friend Mr. Rahul said was regarding cancellation. 3 aspects have been pointed out.
Yes.
Number 1 was passing of GOMS number 33. Second was the change in the procedure in 29. Issuance of GOMS number 16, which was relating to 60 additional posts.
Yes.
My lord, begging a question to myself, if at all and if only the Public Service Commission was right in conducting the examination, which majority of times it's not, would they have the plea to make all these objections at all? So, you do a mistake, examination is cancelled, you gain an advantage. How is it equitable? If the examination took place and took in the proper manner, could 33, which has been passed in 22,
Yes.
be redone in 24?
Yes.
My lord, kindly appreciate a great factor which took place between the first notification and the second notification.
Yes.
First notification came in 22.
Yes.
I don't need to say more than that. Second notification came in February 2024.
Yes.
There has been a change in the society. That change in the society is the reason for cancellation. A constitutional body with great respect appeared to have surrendered its discretion to a political thing. Otherwise, 22, it's not as though 33 came yesterday. 33 was available from September 2022.
Subsequent to notification.
Could be. So, if 33 was the situation, you could have cancelled even before the first preliminary. You never did it. You have also not bothered about all these things. And look at the funniest statement made by the Public Service Commission. For the 60 posts, do you mean to say we will have to conduct new selections? This was the question posed by the Public Service Commission, if I may say so, with the least of the responsibility expected from a constitutional body. If there are 2 posts, will you say, no, I will not do it? Does it lie in the mouth to say that I am a constitutional body? If you give not below, it's just like purchasing a thing in DMart. You will have to purchase at least 50 packets of Agro biscuits, then only I will sell you. DMart Metro. Is Public Service Commission a metro? Which says I will not conduct the examination if it is less than 2 or 20? Or do we need to infer something else from that also? If there are 500, the percentage would be good. For what purpose? I leave it to your lordship's discretion. What is that they are trying to tell and sell before this court? Obnoxious, with great respect to say the least. So, you add up the vacancies, you show the rules of 33 only because you have committed a mistake. Let us take one logical question, my lord. I will make this statement only insofar as fairness is concerned.
Yes.
22, you conduct an examination, issue a notification. Selections for once in the history of the Public Service Commission goes in accordance with the calendar, in accordance with that, with no case being filed, impossibility. But still, let us presume that, let us test it to the extremity. Could this election have been postponed till February 2024? The answer can be no. If that is the situation, could your 33, could your 16 and could your 29 be used as a reason for cancelling the examination? And Another statement which has been made by the learned, counsel for the respondent was, we followed the order of the court. My lord, I may have to tell them that following the order has some legal significance, and that some legal significance will have to be understood only by the wording of the order. Kindly go to the order of the learned single judge. What did the learned single judge say, and how have you the courage to come to the constitutional court and say that we have followed the order? This is where, my lord, I have been telling you, this honorable court, consistently with great respect, that I am the law unto myself is the only attitude with which the Public Service Commission works. Kindly go to page 66, filed along with my writ petition.
Yes.
That is the internal page 16 of Her Lordship Justice Madhavi Devi's judgment, my lord.
Right.
7 lines from the bottom.
Yes.
Therefore, my lord got that sentence. To prevent any injustice being caused to them, this court is inclined to cancel the Group 1 preliminary examination conducted on 11/6/2023 and to direct the respondent to reconduct the preliminary examination. That's all. If you have done anything other than that, how does the Public Service Commission call itself to have implemented the order of the court? The division bench did not modify this. They said the learned single judge was absolutely right in doing it. We don't want to interfere. Then finally, to avoid confusion also, my lord, they said the same thing. At page 17, thus the respondent does not seem to be careful either in conducting the examination or in correlating the data who appeared for the examination in spite of its importance and its impact on the candidates appearing for the examination. This is an observation. Fantastically, they went right up to Supreme Court, and on 19/2/2024, they did 3 actions. Number 1, withdraw the appeal before the Supreme Court.
Yes.
If they were aggrieved by this submission is clear. This order of the learned single judge is clearly stating that what we have been saying, you are incapable of conducting the examination. This is exactly what this court said. You have carried the matter. Why did you fight shy to get that annulled? Why did you not say that we are the best persons world over must learn from how we conduct the examination? You had an opportunity. You knocked the doors of Supreme Court. Why did you withdraw it? So obviously, the second principle will come. Yes. We now get a mistake and we will use it for our other mileage. And that is the reason why in 1922, 3 things happened, as I told your lordship. One is withdrawing of the appeal. Second is cancelling by virtue of issuing web note. And third is in issuing a fresh notification, incorporating new vacancies. Yes. For the purpose of those 60 vacancies, persons who were not even graduates will now compete, and 503 vacancies, they will get it. How is it a fair way of conducting the examination? This is one greatest thing to say, that we are now confronted with a constitutional underline which doesn't follow constitution and has least regard for fairness. And they will use every mistake for their own benefit. That is what would be established by this conduct of theirs. Then the second aspect is, we are in a glass house and we have the audacity, with great respect, to say how a candidate should prepare. Yesterday I have heard for the first time in my life, you will have to use your conscious head. Let the Public Service Commission or the counsel who said that statement tell this honorable court and enlighten us as to how you will use your unconscious head. If you are unconscious, your head doesn't work. Obviously, that's how this subject experts must have prepared. So they are expecting ourselves to work with a conscious head. I don't know what that means. And another startling example coming from a Public Service Commission is, because you are Group 1 examination, 1 + 1, if 2 is not given as an answer, you should not crib about it. You must write 1, because you will have to read so many things. So you can take it 1 divided by 1 is equal to 1, 1 minus 1 is equal to 1 according to Public Service Commission, 1 into 1 is 1. So your vista should be so broad not to see the right answer. How ridiculous this is, my lord. Yesterday my learned friend was trying to say 1 + 1, a Group 1 person should not write 2. Is this the merit which they are expecting? And is this the merit on which the papers are tested? If this is the merit, we would have a rotten bureaucracy, with great respect, for next 30 years. Merit will always be at the altar if such a statement is made. And most importantly, my lord, I pick up one sentence from the expert's book. Read that which is convenient, ignore what that is not convenient. This is yet another fairness of the Public Service Commission. I will demonstrate this particular thing from the questions which they have answered to say this will have to go. And another important aspect is, my lord, Why do you give statistics? 0.0001% has asked. Yes, 1% said Rama killed Ravana is the correct answer. You may have given doled out mark to me, but your answer is wrong. This is not meritorious. I am ready to forego my mark. How does it bother the Public Service Commission? Continuously, if you're fortunately, and as this is called a divine justice, my learned friend never touched upon the merits of question number 41. He simply said, we doled out marks to 3 petitioners. Take it out from me. You take those 3 marks away. So the fact that you agree 41 is not a subject which you have raised, you did not touch on the merits of it. You only said 41 was written by Mr. Damodar Reddy, Ellaya, Pullaya, Mallaya. They all got 1 mark. Now how can they raise an objection? Two-pronged reply is what I would like to give for it. Number 1 is, who raised an objection is not the criteria to decide whether this is the right answer or wrong answer. This is not a demand and denial. This is a question where Telangana, which is the capital city of Telangana, if Hyderabad is not an option, in spite of the fact that you are a Group 1 officer or a probable Group 1 officer who may eventually become the Secretary of the Public Service Commission, it doesn't become Rangareddy district. So you have doled out marks. That itself indicates that you do not know how to pick up merit. So if you have given mark and you take it as a credit, God save our country. So 41, my lord, they have not answered anything on that. My learned friend was springing into action. Perhaps he will give a reply to reply which is unheard of, but let us leave it for the time being. Yesterday when the argument was advanced, 41, whether it is right or not, was not even debated. They went with 66. So if one question is wrong, that would definitely make or mar the entire thing. Your lordships are aware of a scheduled tribe woman who was the last of the person in the preliminary examination. She topped the civil services examination. So at the threshold, you throw us out and say you are anyhow not within this bracket. You are forcing a probable number 1 out of the reckoning. What business have you got to do it? Is a question which I pose to myself. Then the second question is, my lord, 66. 66 question, they read certain material and they would say further thing. We have exactly copied what has been given in the sentence. Your own source says in 2 languages, which of us is right, your experts do not know. And because I have copied that, that's the only answer if your understanding is that. With greatest respect to the knowledge of the subject expert, it doesn't deserve to be called a subject expert at all. Your own material would say that it is called a road bridge, and kindly see the very document which they have paraded before your lordship on this subject. It goes on further to say something, but I pick up and underline. Previously, my lord, we used to seek pardon from the court for underlining it, saying that it was only for our reference. Yes. But nowadays, that seems to be the thing. Your lordships and anybody should read only that and nothing else. That seems to be the tendency nowadays. Because we have advanced in our aspects so much that we have got a myopic view of everything. The material which they have filed, my lord, if your lordship sees in the counter affidavit, the document which my learned friend was reading was, and commenting upon people. They are not supposed to read only one Telugu Academy book. Who knows what they have read? At any rate, does the Public Service Commission know what they have read? Why are you making comments just like that? They ought to have a broader outlook. They must not read only Telugu. Did anyone tell the Public Service Commission that I read only Telugu Academy? Supposing he has read only Telugu Academy, do I forfeit my right to say that Hyderabad is the capital of Telangana? Well, there is no need for us to boil our blood. But the fact is, just like driving in the old city, my lord. If your lordship have little experience in driving in old city, that man will come and knock us and he will start his Hyderabad dictionary. So we will have to say sorry. This seems to be the attitude of the Public Service Commission.
Ulta chor kotwal kuda.
Exactly. That's it. Now kindly see page number 66 filed, page number 46 filed along with counter affidavit in respect of 66. Yes. Perhaps your lordship must have got the papers and question numbers much faster than us. I am grateful to your lordship. Yes. The sentence which was read was only the first one.
Yes.
Is an under construction 21.8 road bridge connecting Indian city, Mumbai and Navi Mumbai. They read this sentence only to say road bridge connecting Indian city, Navi Mumbai. If a person reads broadly, as was expected by the government leader and the Public Service Commission, should we stop at that or should we read the next sentence? If we read so broadly, it further says this. It's a satellite city. When it completed, it would be a longest sea bridge in India. So your broad reading will have to be shut at, because this question we are saying, you will have to have only a needle point vision because this suits your convenience. But if this is wrong, you would say you will have to read everything. What is this? You can't read one sentence and come and argue. This, in my humble submission, is exactly what I said to your lordships. So if you read the entire thing as broadly as possible, this is susceptible to two answers. And I also said while during the main argument, my lord, I construct a bridge today. It will not become a railway track tomorrow. And when the material source which you have produced itself uses both sea bridge and road bridge, and you only say you will have to take a wrong conspectus of everything, you can't ask 1 + 1 = 2, and that answer, if it is not there, you can't complain. When that is your understanding on the entire issue, why not the sea bridge can be read? This is a person who come before this honorable court and say, I read through the entire thing, Public Service Commission is reading only one line, ask him to expand his vision. He has been benevolent in becoming a Sukha and Parasara for the rest of the world. Let him follow it from the home. This is what the petitioners are saying. How is it wrong? Questioning to myself. It's absolutely not wrong. So therefore, the 66th question, my lord, quote unquote their own quotations, their reading is myopic and absolutely saying I will not see. Just like a horse has that, covers in the end, and it will only go one row. Jatka Gurran Laga on the pitch, it doesn't seem to be a so-called broad vision which they are supposed to have. Therefore, 66 will have to willy-nilly go. Then, my lord, kindly see Parabrahma Shastri, that is 79.
Yes.
This is where I was trying to say. I read selectively one sentence and say this is the end of the matter.
Yes.
This reading one sentence is restricted only to Public Service Commission because they have already become bureaucrats. But a person who wants to be bureaucrat, he will have to read everything, but not say what you have said is wrong. Strange and funny, both at the same time. My lord, yesterday, my learned friend sent Telugu Academy one paper. He said, we have filed one. He has filed something different. And that something different is only one thing which we have given. Whereas the other one material which we have is now the Bible and the last word on the subject. To substantiate this wonderful argument, my learned friend circulated to your lordship for the second time this Kakatiyas of Warangal by B. Parabrahma Shastri.
Yes.
Though it's filed in the counter, they said, twice if I give, that would be more emphasis.
Yes.
Therefore, they have given that. Kindly see the 281 for one moment, my lord.
Yes.
If your lordship got that paper, my lord, 281. This is what we'll have to read. As far as Andhra is concerned, the sectarian conflicts between Veerashaivas and followers of other faiths did not develop into religious conflicts as in Karnataka during the period. So, the conflict is between Veerashaivas and the followers of other faiths. Veerashaiva, if at all these historians who are the experts in this subject would know, Shaiva and Veerashaiva itself is two different sects in the Shaivism. In Karnataka, you have got what is called Lingayats. They are a breed in Shaivites itself who adore Linga on their body, and they are never cremated as a Hindu, though they are Hindus. Because their belief is, since Linga is on our body, they will only be, buried, not burnt. This is Veerashaivism. So in Karnataka, there was such a Shaivism between so and so, Veerashaivas and Shaivas, and in other sectors, sectarian conflict. It was all due to the tolerance attitude of Kakatiya that the society at large could rather assimilate and vehemently oppose the doctrines of other sects. This was paraded to your lordships to say that there was no liberal. But this was abandoned. If I may use the expression with utmost respect, Telugu history and culture. Your lordship may kindly see this document. This was furnished by my learned friend was arguing.
Yes.
Kindly see this document.
Yes.
This is where I was saying this underlining business has been used for ensuring that the court doesn't expand its vision peculiarly. My lord, kindly go to the last portion,
Yes.
which they have underlined again. First paragraph, my lord. Unnumbered paragraph 2, which starts with during the Ganapati Deva. during the time of Ganapati Deva. This is internal page 204 of that paper, my lord.
Yes.
This separate one which has been given.
1 minute.
Yes, ma'am.
204.
Yes, ma'am. At the bottom, your lordship should get it. After the Telangana emblem was printed on the number, your lordship get 204. Last Vaishnavism chapter is what a separate chapter is. My lord, I think your lordship may have to see the separate page, my lord, which was furnished on the last occasion, yesterday. This was separately given. Because we relied on Telugu Academy. They said we have not given the full one and they gave this. I filed 193.
You have filed?
They have circulated it yesterday, my lord. I have filed the document.
Yes, yes. Got it. Yes.
Yes, ma'am.
Proceed.
Kindly go to Vaishnavism is the chapter. 5 lines on the top, from above that, my lord, in that paragraph, your lordship will get a sentence which starts like this. The temple pujari is called Maheshwaralu. Your lordship got that sentence, my lord?
Yes.
Last 4
Yes,
lines
yes.
from the bottom of the paragraph.
Yes, yes, read.
Yes, sir. The temple pujaris called Maheshwaralu became very powerful. The policy of religious tolerance of Kakatiyas towards other religions helped in sowing seeds of tolerance among all religious sects of the period. During that time, in Karnataka, conflicts and disturbances between Veera Shaiva and Shaiva sects developed, and the same we do not find in Andhra Desha. Karnataka, some portion also is the Kakatiya Empire only. Kakatiya dynasty spans over to some portions of Karnataka also. Then kindly see the next page. They would underline certain things, but the underlining is, according to me, a little bit mischievous. Kindly go to the last ruler of very next page, my lord.
Yes.
The last ruler of Kakatiyas, Prataparudra II.
Yes.
This 2 is also important. Prataparudra II, in AD 1321, gave some donations to Chennakesava Swami temple. Is mentioned in the inscriptions. His queen Lakshmi Devi donated some gifts to the Ramanatha temple in Ellada. During the Kakatiya period in Telugu region at Simhachalam, Sarpavaram, Macherla, Ahobila, Dharmapuri, Tirupati, Srikurmam, Mangalagiri, Ponnuru, Nelluru, etc. are the places where many Vishnumurti temples were constructed. The Battle of Palnadu, known as Palnati Veeracharitra, belongs to this period. In reality, is a war between supporters of Veera Vaishnava and sect Brahmanaidu and Shaivite leader Nayakuralu Nagamma.
Yes.
Then how do they say it's not rivalry? Now they pause it here. After the battle is over, Brahmanaidu started preaching Vaishnavism and saying all gods are equal. That portion is underlined for your lordship, sir. Like this, Kakatiya become, like this means what? You should have read that also and said that. They don't read it obviously because they want your lordships to only believe that they were harmoniously working together. Shivaratri and Vaikunta Ekadasi were celebrated in the same house. I give you Vibhuti, you give me Gandham. But that's not what is contained in this very same book.
Yes.
So therefore my submission is, my lord, I don't use the expression, but the correct expression is trying to mislead the export. That takes fully care of, my lord, 79. Then let us go to another wonderful question. Singamanayaka 2.
Yes.
In this, in spite of telling them, in spite of their reference books having Roman 2, Roman 3, Roman 1, and telling again this quote as a main argument that as soon as that is available, you will have to do it. I reiterate my example of Shakespeare once again, my lord, and also give a different example. Who is the hero in Abhinandana? Pardon me for using this expression. We have one name, Mr. K. Answer given is JPK. Now, clearly because K is available, a person who is occupying some other post, can he be said he is the person who is acting in Abhinandana? How far is it fair, my lord? And your book contains Singamanayaka 2. Why should I take anything? And names, authors, places and capitals, they are all best answers liable to be given. That is the merit according to them. Is it not laughable to say the least? If a book is written by Shakespeare, it is written by Shakespeare or no other person. Why are they acting too smart? Why should they say Singamanayaka 2? 2 is given by some Roman. Okay, 2 is given by Roman. Why did you include that in your junior lecturer paper of history? Your lordship should find Roman 1, Roman 2. That's okay for that. Whereas in this, some Roman added Roman 2. Why should we add Roman 2? We are all Arabic Roman 2. We will write 2. Or we will not write it at all. This, in my humble submission, is with great respect, adamancy not to see the logic. So therefore, my lord, the Singamanayaka question will also have to be accepted.
Yes.
Then, my lord, Kuli Kutub Shah architecture. You circulate.
Yes, proceed.
You circulate papers of Hyderabad tourism.
How much time will take?
Under 5 minutes, my lord. Only one more question is left over, my lord. Kuli Kutub Shah and that 119. These are the 2 questions. I will be done with it, my lord.
Yes.
So this Kuli Kutub Shah, the material that has been paraded is all the things of tourism department. And in the reply, I have given a leading historian, at least to the limited knowledge of my clients, that Sherwani is considered to be an authority on Kuli Kutub Shah dynasty. And I have also told, I have no personal knowledge, I have also been told, no research paper on Kuli Kutub Shah dynasty could be complete without referring to Sherwani. And that Sherwani's book specifically says Mughal influence was available. Now you deal only with Kuli Kutub Shahi tombs, which is not the only building that was constructed during the period, and you reiterate saying that this material is the be all and end all of the matter. Then how do you not count Marichanna Reddy Institute of Human Resource Development material? That's also written by Tom and Dick and Harry. We'll take that. And these are the things which you are going to teach for these officers from tomorrow onwards. So your material prepared for the purpose of training is good. But when you are confronted with the very same material saying that it had Mughal influence, you will abandon it. In my humble submission, my lord, this is not underlined, not a fair way of assisting the court from a constitutional body which will have nothing in person. It should have the magnanimity to own up the mistake. Unfortunately and repeatedly when they are saying also, they are taking pride in their mistakes rather than owning up the magnanimity, owning up it with magnanimity. Then the last question is, my lord, 119. This is the ridiculous explanation which I can never think of. Because between the material which is directly constitution and the National Commission, this Public Service Commission wants your lordships to take a secondary source as the basis to non-suit the petitioners. How far is it expected from a constitutional body? And kindly see whether that National Commission also did the same thing in the manner in which they want your lordships to believe will be available by reading that very material. And here also you will only underline. Don't see anything else. You are bonded. You are supposed to read only this and nothing more. Kindly see this wonderful explanation given. And the source, I don't say it is funny, but the source is not the be all and end all of the matter. Kindly go to page 75, my lord, filed along with the counter affidavit.
Yes.
This is the 5th report or 6th report, we do not know. Kindly go to social safeguards.
Yes.
Article 17, 23, 24 and 25 by 2, Constitution enjoins the state to provide, etc. I'll leave that. We'll go to 23, which is a question. 23 prohibits traffic in human beings and beggars and other similar forms of forced labor and provides that any contravention of this provision shall be an offence punishable in accordance with law. Faithfully, article extracted. Then, although there is no specific mentions about scheduled caste in this article, so their own material says it doesn't talk of scheduled caste. Then, underlined portion. This is underlined portion is what is according to me mischievous. But majority of the bonded labor come from scheduled caste. Have you conducted an empirical study on this? Supposing you have conducted an empirical study and all the bonded labor in the country are scheduled caste also, does it alter the article? The answer can only be no. You are not a constitution maker, nor is the commission a constitution maker. Constitution maker said, A is this. Who are you to interpret this? If you can't interpret that and you have no power to rewrite the constitution in the manner in which you want, without even having a basic empirical study on whether this statement is right or wrong, how does the Public Service Commission say that you will have to read broadly irrelevant things. When I am preparing for a group 1 examination, I will have to read about Pawan Kalyan's movie. Is that what I am supposed to do? Your own statement says it doesn't deal with scheduled castes, and you have the cheek to come and tell this court saying that this is what we will have to do. Then read about 24 also. This also same in the same language.
Yes.
Article 24 provides that no child below the age of 14 years shall be employed. No child. There also the article is truthfully extracted. Then commentary begins. Even in this article, there is no specific mention about SCs. Then is your question rightly framed? The answer is no, and even this material doesn't support you. And then, but substantial portion of the child labor. So according to you, some XYZ, however high it may be, would surpass the constitution is the least that is expected from a subject expert. So therefore, my lord, the article which is given, you have two sources before your lordships. One is exactly the constitution, the other one is an understanding of the constitution. I may understand the constitution wrongly. Article 14, if your lordships were to read, it's only one sentence. But if that sentence is asked, your lordship would not be saying you read Maneka Gandhi, you read Charan Singh Sahu, all those things your lordship would not be saying. What does the article per se say? If that is the question, per se what it says. But the answer which they are trying to say is substantial without there being any method and madness. So therefore my humble submission is, my lord, except repeatedly saying that you have not appeared, you have not done, and this question is wrong. I'd only read one judgment, my lord, only one judgment. That also this has been cited. Rishal versus State of Rajasthan. This will answer their question, or the greatest question if they have is, you have not raised an objection.
Yes.
I have not raised an objection, therefore I should not ask whether it is right or wrong. Ravana killed Rama, and no, Krishna killed Ravana, and I should have to shut my mouth. This is their understanding, and this is what they have been parading before your lordship. Rishal Singh is a judgment reported in 2018. That also has been circulated to your lordships, my lord. 2018, volume 8 SEC, page 81.
Yes.
My lord, the judgment relies on earlier judgment of. I'm sorry.
Yes.
Rishal Singh, it refers to one judgment of Maharshi.
You have cited that judgment.
I have cited.
You have cited.
I have cited, my lord. That.
Yeah, my learned friend has given that. Rishal Singh versus Rajasthan Public Service Commission and others. If that's not readily available, my lord, I'll circulate during the lunchtime, my lord. I'll read only those paragraphs and circulate it during the lunchtime. My lord, it relies on an extract of the judgment rendered in Manish Ujjwal versus Maharshi Dayanand Saraswati University. Last three lines, my lord, which should make interesting reading. 83. That's it. Page number 83. Page 88 is what I am requesting your lordship to kindly look into, my lord.
Internal page number?
Yeah, 88, my lord. That would be para number 15.
Yes, read.
Para 15 talks about the issue pertaining to scope, etc. But I will not trouble your lordship reading everything.
Yes.
I'll take your lordship straight to para 16, which is an extract from Manish Ujjwal versus Maharshi Dayanand Saraswati. Last Placitum G onwards, your lordship may look into, my lord.
Richal versus
Rishal, yes, sir, Richal. That's
Richal versus Rajasthan Public Service Commission.
Correct. Rajasthan State Public Service.
Para 15. Internal page number?
That's 89, my lord. Para 15 is at 87. I am drawing your lordship's attention to 88.
No, page numbers are not tallying.
On the top,
SCC
the judgment page numbers.
No,
SCC.
it's not SCC.
SCC ఇవ్వలేదు అనుకుంటా నేను
Please pass on that.
SCC.
And national, that national citation could be there, madam.
Yes.
Nowadays we are getting that, but somehow. I am reading only from SCC only, my lord. Kindly go to para
Page
88.
number? Page 80?
Page 88, my lord. Para 16.
88. Yes, read.
They are writing this, my lord. Following the above judgment of Kanpur University, that is Samir Gupta, this court in Manish Ujjwal, etc., reiterated the principle in the following lines. I'll skip everything. Kindly go to Placitum G, which starts with a sentence as already noticed. Your lordship got that?
Yes.
As already noticed, the key answers are palpably and demonstrably erroneous. In that view of the matter, the student community, whether the appellants or interveners or even those who did not approach the court or this court, cannot be made to suffer on account of errors committed by the university. This principle has also been reiterated in this, while this has been quoted approvingly. So therefore, my submission is, my lord, just because I don't question that Telangana, capital of Telangana is Hyderabad, and you write Warangal, I have not raised an objection, therefore Warangal is the right answer in my humble submission, cannot be done. Even to the person who does not come to the court also, the courts have been saying extend it, because it looks ridiculous. For one person who came to this, Telangana's capital would be Hyderabad. For a person who has not come to this, it will be Warangal, because I have already given a mark. In my humble submission, it's very funny. So therefore, my summing up in one sentence, my lord, fairness is one thing which the Public Service Commission does not believe. Starts from notification. Lest such an objection come, my lord, I advise my people not to question the notification because they have already participated. Otherwise, if you have come at this stage, this notification is the most mischievous notification that could have ever been issued. And to cap it to say that we have followed the order, my lord, it would have been a clear case of contempt. But be that as it may, only to say the lack of fairness, I am trying to say this. And second aspect is, my lord, they don't want to see logic. They want your lordships also to see only a, a minuscule logic which lacks logic. And therefore, my lord, this will have to go. 33,000 prepared. The example of Dabi, or I don't get her name rightly, my lord, is a classic case. She may have missed the bus in the preliminary. If you have rightly corrected, all these persons who are here or those who are not even here may be a topper. So 35,000 I have given, they got the benefit because of my wrong key, is the last thing that is expected from the constitutional authority, which praises itself of conducting the examination fairly, though it does not believe in fairness. That's all, my lord. I am grateful to your lordship.
Yes, Rahul, merit, please.
I'm sorry, Bullet. I'm sorry, Bullet. I'm sorry.
List of the entire preliminary, only to the petitioners, my lord. Yes, my lord. I think.
Yes.
My lord, I'm sorry.
Yes,
84 item, my lord.
84 will issue notice. No, we won't club it.
Issue notice. Yeah, Lordship issue notice.
84, fresh item.
Yes.
Yes.
And my lord,
In that what all we are,
no.
one second, Rahul. Sorry.
Yes.
In that what all we are asking, my lord, is that they are all.
No, that we will hear later, not now.
Yes.
Notice for admission. 84. GP, sir, additionally, takes notice for respondents and is post after 4 weeks. Yes.
Please, lordships.
No mention.
I'm sorry, my lord. So far as I know, my lord, there is no reply to reply. Lord, but there are some aspects, my lord, your lordships to recollect, because they have not raised the objections. Your lordships also, my lord, it was an understanding that we didn't have to express those questions also. But at question number 41, my lord, though we were to refer, since two people who have raised the objections have got the marks, and the rest, my lord, who did not object, did not, my lord, qualify. Lord, we thought it was not necessary, my lord, but if it was something that is to be considered, my lord, we have answers which we have filed for questions also, my lord. There is a direct preposition on question number 41. My lord, insofar as the other aspects, my lord, as we have said, that all the petitioners, my lord, have not raised the objections. Only 2 petitioners have raised the objections.
We will continue.
I'm sorry.
In the afternoon, my lord, your lordship,
Yes,
may pardon my absence, my lord, and I am grateful for your lordship's patient
that all the petitioners, my lord, have not raised the objections. Only 2 petitioners have raised the
We
objections.
will continue.
I'm sorry.
In the afternoon, my lord, your lordship,
Yes,
may pardon my absence, my lord, and I am grateful for your lordship's patient